Recently, the Securities and Exchange Commission said that XRP is a security. This is a ridiculous claim that has nothing to do with the SEC vs. Ripple lawsuit or the appeal. For derivatives and secondary market deals, which are both parts of the XRP ecosystem, this has nothing to do with them at all. John Deaton is an attorney who has been working against the SEC for a long time. He recently wrote an article on X in which he talked about this subject. Now, the opinions of Bill Morgan and James Murphy, two more lawyers in the XRP community, were also given about the government agency's random decisions. They say that the Securities and Exchange Commission is making decisions that are completely random and hurt cryptoland, especially those who are trying to get their finances in order. This trend has been getting worse since the current administration took office, and Harris, who is running for president, barely talks about cryptocurrency. Bearable Bull sued the SEC and its 5 commissioners, saying that the government had gone too far by saying that XRP is a security. This is just one example of how the Securities and Exchange Commission (SEC) fights anything related to the XRP ecosystem. Anything that helps XRP hurts Bitnomial and Ripple, which is the SEC's main enemy. But the SEC is still pushing for Bitnomial to be controlled as a security, even though their most recent case against Ripple did not go well. One of the things that made Bitnomial decide to sue the Securities and Exchange Commission was Judge Torres' decision that XRP is not a property. On the other hand, they were giving that information as if it would support the SEC's point of view that they need to register for futures trades because these deals are illegal when it comes to stocks. Some people have said that the Securities and Exchange Commission's actions were unfair and were aimed at the XRP environment. This is because XRP is already listed as a commodity, which means that the Commodities Futures Trading Commission is the only agency that can regulate it. It is clear that this move goes against both the SEC's authority and the interests of the cryptocurrency community. That being said, the SEC's claims about the security status of XRP are completely false and have caused a lot of worry in the XRP community. The SEC's actions are meant to improve their position, but they could hurt the XRP ecosystem as well. Went to court with $75,000 of his own money to fight Gary Guinness for 75,000 XRP token users, including 627 in Massachusetts. The other person was George Guinness. But a judge who had always been a Democrat and was picked by Barack Obama agreed with him and used some of the information and instruction that was given to the court. In the end, he decided that the Securities and Exchange Commission could not get a better grade. The SEC and other groups say it was very clear from the judge's words that XRP is not a security. During the case, a federal court found that the lawyers for the Securities and Exchange Commission did not follow the law with all their heart. He also called them liars who would say anything to get what they wanted. A magistrate judge named Serenette Byrne was very harsh on the Securities and Exchange Commission for lying and not really following the rules. Senator Warren, who was also a special assistant United States attorney, was very angry about what the Securities and Exchange Commission was doing. She made it clear that she was set on bringing down the cryptocurrency business. Senator Warren gave Guinness a list of questions and answers at a Senate hearing, which Guinness could use before the whole thing. Further research revealed that she was motivated by her desire to bring down the cryptocurrency market and other institutions that she had been said to be against in the past. It's interesting to hear what lawyer Deaton has to say about this, and he did a great job with the case. He is now running for the Senate, but he is glad to have the chance to share his thoughts with the XRP community. Bill Morgan, an attorney for the XRP community, has said that he doesn't like the Securities and Exchange Commission's random moves, such as the complaints that Crypto.com and Bit.no.meal have made. The company Bit and Mile is taking action against the Securities and Exchange Commission (SEC) by suing it for saying that XRP is a security, even though Judge Torres made the opposite decision. As Billy Boone showed in his 2018 speech on the Ethereum Free Pass, the Securities and Exchange Commission wants to limit swaps of digital assets to just Bitcoin and Ethereum. The second case involves CoinDesk, a company that sets up markets for cryptocurrencies. That case is called the Cumberland case. The U.S. Stocks and Exchange Commission complained to Cumberland that the cryptocurrency market maker bought and sold cryptocurrencies that were being sold as unregistered stocks. The SEC also said that Cumberland was selling stocks without being registered. The SEC said that Cumberland had used its study papers and notification emails to encourage people to invest in different cryptocurrencies like polygons and other cryptocurrencies. And the Securities and Exchange Commission, on the other hand, keeps saying that the asset itself is the security. They keep saying this even though they said they were sorry for using the term crypto asset security and other forms of that word, but they still do it. Cumberland did not register as a securities agent, which was a bad thing because the investors thought they would make money from these claims. Attorney Morgan has said that the asset itself is the security, and the SEC still says that the asset itself is the security. We've just been made aware of the strange steps the Securities and Exchange Commission SEC took, along with the reports from Crypto.com, BitNoMile, and the sack against Cumberland XRP. People have been unfair to Ethereum and Bitcoin futures contracts because the Securities and Exchange Commission did things that didn't make sense, he said. He also thinks the SEC would rather only let Bitcoin and Ethereum be used as swaps for digital assets. There is a case against Cumberland by the Securities and Exchange Commission which says that the SEC forced the bank to trade either Bitcoin or Ethereum in 2019. Because of the 2019 CC decision that only Bitcoin and Ethereum can be sold. This choice was put into action. It was decided this way because it was thought that Bitcoin did not have clear legal status. Furthermore, there is a 100% chance that the Securities and Exchange Commission will not fight Bitcoin. The Securities and Exchange Commission said what it thought about Ethereum 5 years ago. On the other hand, everyone now knows that Ethereum is legal. According to the Securities and Exchange Commission, this claim is not true. This decision is based on the idea that Ethereum is not a property. Attorney Morgan says that this decision was based on Amin's free pass speech, which confirmed the SEC's official stance that Ethereum was not a security. This opinion was given, it is said, by the cryptocurrency website Crypto.com that the Securities and Exchange Commission treats so-called crypto asset securities differently than it does Bitcoin or Ethereum. Like Bitcoin and Ethereum, the Stocks and Exchange Commission doesn't treat the so-called crypto asset stocks the same way. There are some functional similarities between the tokens on its platform that the SEC says are crypto asset securities in Bitcoin and Ethereum. However, the way Bitcoin and Ethereum are handled arbitrary compared to other cryptocurrencies is making the cryptocurrency market skewed. A member of the XRP community who goes by the name Metal Lawman also thinks that Cumberland has the power to fight the SEC. He believes that every other crypto player who has registered with the SEC has been attacked, even the library, which was a very small project and was one of the targets. The Securities and Exchange Commission, on the other hand, has been using this filing to get people to sue them.